Welcome back to the channel. Today's case is one of the most emotionally charged, legally complex, and morally disturbing situations we've seen in this courtroom series. At the center of it all is Jacarius Avant Francois, a defendant facing a third-degree felony charge for assaulting a pregnant woman, his own partner, and carrying his child. And let me tell you now, the judge in this case is not here to play. From the opening moments, you can feel the tension. There's disbelief, frustration, and a heavy sense of accountability hanging in the air. As we walk through this case, you're going to witness a powerful breakdown of legal procedure from the indictment to the guilty plea to the negotiation of probation terms. But beyond the legal framework, there's something even stronger: the raw human reaction. The judge's emotions, the defendant's responses, and the shocking details of the probable cause affidavit create a courtroom atmosphere that is absolutely unforgettable. This video will take you inside every key moment: why the state pushed for certain probation conditions, why the judge reacted so forcefully, and how the law treats violence against pregnant victims. And trust me, the judge's final ruling? It delivers one of the strongest messages we've heard all year. As we go through the transcript, I'll break down what each legal step means and point out the emotional turning points you might miss at first glance. So buckle up, because this case? It's not just another courtroom drama. It's a way-up call.
Punching a pregnant woman in the stomach. And he's seen the error of his ways? He has? How long did that take? I mean, I don't mean to be facetious, but this is clear to everybody on this planet that this is wrong. We now call cause number 23-41591, the state of Texas versus, God bless you, Jacarius Avant Francois. That's you.
Yes, sir.
And you were here with Mr. Turk, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in a summary
We may just
fashion? In summary, sir, this indictment alleges that on or about December 13th, 2022 in Jefferson County, Texas, you committed a third-degree felony of assault on a pregnant person. Do you understand what you were charged with?
Yes, sir.
A third-degree felony is what this case is all about, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Welcome back to the channel. Today's case is one of the most emotionally charged, legally complex, and morally disturbing situations we've seen in this courtroom series. At the center of it all is Jacarius Avant Francois, a defendant facing a third-degree felony charge for assaulting a pregnant woman, his own partner, and carrying his child. And let me tell you now, the judge in this case is not here to play. From the opening moments, you can feel the tension. There's disbelief, frustration, and a heavy sense of accountability hanging in the air. As we walk through this case, you're going to witness a powerful breakdown of legal procedure from the indictment to the guilty plea to the negotiation of probation terms. But beyond the legal framework, there's something even stronger: the raw human reaction. The judge's emotions, the defendant's responses, and the shocking details of the probable cause affidavit create a courtroom atmosphere that is absolutely unforgettable. This video will take you inside every key moment: why the state pushed for certain probation conditions, why the judge reacted so forcefully, and how the law treats violence against pregnant victims. And trust me, the judge's final ruling? It delivers one of the strongest messages we've heard all year. As we go through the transcript, I'll break down what each legal step means and point out the emotional turning points you might miss at first glance. So buckle up, because this case? It's not just another courtroom drama. It's a way-up call.
Understand?
This one.
Agreement has been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there would be terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
Guilty.
What do you say?
Guilty.
Okay. Are you pleading guilty voluntarily and because you are guilty? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents true and correct? State's Exhibit 1 tendered into evidence without objection admitted within batterers and invention presumption. How long was he in jail? Thanks. Thanks.
Here's where things get especially interesting. The defense clarifies that the defendant has already served 5 months, 153 days, in jail, and this becomes a major factor later during sentencing. Time already served can count towards specific probation conditions, but it does not erase guilt. The state and defense appear coordinated, and that's important. Both sides are agreeing to move forward with deferred adjudication probation, which keeps the defendant from having a final conviction on his record if he completes all terms. But deferred adjudication is not a free pass. The judge still has full authority to impose jail time as a probation condition. What's your take? Does deferred probation seem fair in a case involving a pregnant victim, or should prison have been mandatory?
Thanks.
Judge, Mr. Francois saying he was in jail for 5 months.
Among other things, this states Exhibit 1 that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Yes, sir. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
A record showing this in custody for 153 days on the
That's what she says. Yeah, that's what it's showing. Y'all are working off the same page. That's great. All right. Anything further on this?
No.
I'm going to make the findings that and again, you are pleading guilty today voluntarily and because you are guilty. All right. I'm going to make findings based upon State's Exhibit 1 here that's been signed. That this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's.
Now we reach the critical legal twist. The judge acknowledges that the evidence is strong enough to find the defendant guilty beyond a reasonable doubt, but chooses to defer a finding of guilt to follow the agreement. This is a turning point. Normally, once guilt is confirmed with sufficient evidence, a judge could proceed straight to conviction. But because both sides have negotiated deferred adjudication, the judge holds back on entering a final judgment. However, a key issue emerges. The judge initially mentions that probation length could be shortened with good behavior. The prosecutor immediately corrects this, citing the Texas family violence statutes that strictly prevent early termination in certain domestic violence cases. This correction shows how precise and constrained the law is when it comes to domestic violence involving pregnant victims. Did you catch that tension between the judge and the prosecutor?
State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And you were guilty of this crime and any lesser included offenses. I am going to find, indeed, you are mentally competent to enter this guilty plea. It is freely and voluntarily made, even though there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I'm going to defer any finding of guilt, follow this agreement, and place you on deferred or unadjudicated probation. This will be for 10 years. You do well, it can be shortened to 30. There will be terms and conditions of probation which are focused on this type of case.
I need to interrupt you. On these type of matters, this is an area in which the court cannot reduce the amount of time on the probation on domestic violence related.
I know, I'm going to sentence, I'm going to place him on 10 years deferred or unadjudicated probation.
You made the statement that if he did well, you could reduce it by a third.
Okay.
The law says that you cannot.
I'm sorry.
That's,
Yeah.
We also discussed a 5-year defer.
and that's one of the reasons why I agreed to 5 years in that. And I hate to interrupt the court, but that's the reason why I interrupted the court.
Okay, this Family Violence Act.
Yes, sir. So I'm asking that you approve the 5 years, Judge.
All right, then the court will, and that's agreed upon by the defense. I'm going to follow this recommendation of both parties, and you will be placed on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. The court is looking at this probable cause affidavit, which is most disturbing.
This is where the entire tone of the hearing shifts. When the judge begins reading the probable cause affidavit, you can feel the emotional temperature spike. The details are devastating. A pregnant woman 5 months along, attacked while showering, punched in the stomach, threatened with a knife, and left with visible injuries. The judge pauses multiple times, clearly disturbed, emphasizing how vulnerable the victim was and how reckless the defendant's actions were. This is no longer a technical legal discussion, it's raw human outrage. Judges rarely express this level of emotion unless the facts truly impact them at a moral level. And here, the judge's disgust is unmistakable. What would your reaction be if you were sitting in that courtroom hearing those details?
You're with me? This is for you.
Yes, sir.
This probable cause affidavit is most disturbing. Okay. The victim here was 5 months pregnant with your child. She was taking a shower when you went over to her house, punched her in the stomach. The pregnant lady punched her in the stomach. She was nude. She was unable really to be able to defend herself, put in a bad spot. She says you also picked up a kitchen knife and stated you would kill her. You broke her phone. Police were called. They had visible injuries to her face, scratches on her chin, swollen side of her face. You fled, of course, before the police could arrive. And then, since the incident had occurred, according to the probable cause affidavit, you subsequently called her threatening violent acts. What else could you have done wrong? I can't imagine really a more selfish act could be done than punching a pregnant woman in the stomach. Shame on you. Mr. Man, Mr. Gentleman. And it's your child, right?
Yes, sir.
Punching the mother of your child's stomach, 5 months pregnant. Well, it's about as low as it can get. You've got 153 days. I can sentence you up to 180 days as a condition of probation, and you're going to get all of that. You've still got 27 days to go. You're going to go back to jail. You're going to get every minute of jail that you can. Don't look at him, look at me. I can sentence you as a term of probation to 180 days. You have 153 days credit. You're going to do 27 more. To the last second for this. Yeah.
If I may, Mr. Francois has seen the error of his ways, and he is currently enrolled.
How does he take back punching a pregnant woman in the stomach? And he's seen the error of his ways. He has. How long did that take?
This confrontation between the judge and defense attorney is one of the most intense you'll ever see. The defense attempts to humanize the defendant, mentioning rehabilitation efforts, programs, and personal growth, but the judge fires back instantly. The judge's rhetorical questions, "How do you take back punching a pregnant woman?" cut straight to the heart of the issue. And this is where the judge draws a harsh but necessary line. Consequences are not optional. The judge emphasizes that remorse cannot undo harm, especially when the victim was pregnant and defenseless. It's a teaching moment for the courtroom and for viewers. In criminal cases involving violence against pregnant victims, emotional appeals often hold far less weight than the hard facts. Do you think the judge's pushback here was justified or too harsh?
I don't mean to be facetious, but this is clear to everybody on this planet that this is wrong. And I couldn't care less the way you think about this. Really? What are you upset about? That you're being held accountable to assaulting a pregnant woman? This upsets you? You find something unfair about this? Speak. Do you? Or do you think this is atonement for what a terrible error you did? Or am I putting words in your mouth? Because I don't hear much regret.
Your Honor, I'm not saying anything I did was right.
Okay. All right. So, yeah, go ahead.
Yes. I have made changes in my life.
How do you take back punching a pregnant woman in the stomach? And what kind of harm can that do to a fetus?
I can't.
Immeasurable. No, you can't. But you can, by your actions, do better. You can also, by the terms and conditions of probation that I'm going to set, be an example for others that this is not acceptable. You're going to talk to him while I'm speaking to you?
Oh, sorry.
Is this boring you?
No, sir.
What?
Judge, if I might finish.
Go ahead.
He's been on bond for 2 years at this point, had no issues. He is currently enrolled in a welding certification process. He graduates next month. So putting him in prison right now, or in jail, thwarts his entire life. I understand what I'm saying is at that point you're setting.
You think I'm sorry for him? I feel sorry for the fetus and the pregnant lady who he punched at 5 years, at 5 months pregnant. That's who I'm feeling concerned about. Or am I missing the boat here, gentlemen?
You're not at all, Judge, but I will.
He's going to do 180 days and he still has 27 days. Do you work on weekends?
No, sir. Only Monday through Friday.
Okay, then you can serve it on weekends so you can keep your work.
Okay.
You check in at 6 on or before 6 o'clock every Friday. You've got 27 days
Yes, sir.
to do it on successive weekends.
Yes, sir.
And you're going to begin this coming Friday.
Yes, sir.
The
Thank you,
weekend after
Judge.
Thanksgiving?
Sir?
The weekend after Thanksgiving? This Friday?
This weekend.
Just making sure I understand.
No, yeah, this weekend.
This weekend.
I just,
It's been cool.
this is the kind of thing that's not even a question. This is clear that this is most serious and disturbing. And how you thought that this was going to solve any kind of relationship problem, it defies imagination of any reasonable person. And it wouldn't be, I wouldn't be doing my job if I didn't stand for something. And that is this kind of behavior deserves punishment. And I'm not going to be light on what I can do under these circumstances. I'm going to protect fetuses and pregnant ladies. I have a feeling that you regret what you did. I really do. But I wish you would have called me an hour before you went over and said, I'm about to do something foolish. Help me make the right choice, Judge. And I'd have helped you. Because this one is clear. This was a bad choice. And you're just lucky that is the child fine? Appears to be fine? Well, then thank our Creator. for taking care of it, of the child, but it wasn't because of you. Are you going to take care of the child in your responsibilities under the law
Yes, sir.
and nature,
Yes, sir.
and treat the child with love?
Yes, sir.
And the mother, y'all didn't get married or anything.
No, sir.
No. But nonetheless, are you going to respect the mother of the child?
Yes, sir.
And that brings us to the end of this emotionally charged hearing. In the final moments, the judge delivers a powerful message, one emphasizing accountability, protection of pregnant victims, and the hope that the defendant truly commits to changing his life. The defendant receives 5 years of deferred adjudication probation, 27 additional days of weekend jail time, and a stern warning that the court will protect both expectant mothers and unborn children with full force. This case highlights not only the legal consequences of domestic violence, but the emotional and moral expectations the justice system places on offenders moving forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.